In the 1991 landmark case of Gilmer v. Interstate Johnson, the Supreme Court held that mandatory arbitration clauses were constitutional. These clauses, often found in employment contracts, resolve conflicts between employees and employers through third-party arbitration, rather than through the court system. As companies realized the advantages of arbitration clauses, this case opened the floodgates for their use. In 1991, only 2% of employees were subject to forced arbitration clauses. A mere decade later, that rose to over 25%, and today, over half of all employees are subject to forced arbitration. These clauses are now common in employment contracts in nearly every field, with many of the nation's largest employers requiring them. Companies have extolled the benefits of arbitration, claiming it saves time and money by preventing litigation, while also protecting the parties involved in a dispute from negative publicity. So, how do these arbitration agreements work in practice? Let's start at the moment of hiring. We have two employees, Lisa and Annie. Lisa signs an employment contract without an arbitration clause. Lisa has a dispute at work. She files a charge with the Equal Employment Opportunity Commission and enters into non-binding mediation with her employer. If they can't come to an agreement during mediation, the EEOC starts investigating the incident and gathering evidence. This process can take more than 6 months and necessitates the involvement of a number of third parties to the dispute. The EEOC will try to make a settlement with the company, but if Lisa is unsatisfied with the settlement reached, she can always reject it and file suit in federal court. The mean time to begin trial is approximately 700 days, or nearly 2 years. This process is lengthy, expensive, and public. Annie signs a contract with an arbitration clause. She has a similar dispute at work. Because of her employment contract, she must submit a demand for arbitration. Next, an arbitrator is appointed, typically by the employer. The investigation then begins and is time-bound according to the terms in Annie's employment contract. After the hearing, the arbitrator rules within 30 days. The average time to the hearing is 1 year. Throughout this process, Annie may be represented by a lawyer, but lawyers are often reluctant to take arbitration cases. Once a final decision is reached, there is no appeals process. Annie's arbitration clause includes a non-disclosure agreement, meaning that the initial complaint, the evidence uncovered, and the final ruling are completely confidential. This sounds more efficient, right?
But wait a second. How might we think about this differently if Annie and Lisa are bringing sexual harassment suits? The narrative often goes that employees have a choice whether or not to sign an employment contract that includes a mandatory arbitration clause. But is this really the case? Oftentimes, that so-called choice comes down to either being employed and giving up one's due process rights, or being unemployed. We label this as consent, but when arbitration is so prevalent, doesn't it look more like coercion? In reality, arbitration proceedings skew heavily in favor of employers. Employees win arbitration proceedings only a fifth of the time, about half as often as they do in federal court, and a third as often as they do in state court. When they do win, employees recover less in damages in arbitration proceedings, only 20% of the median award in federal court and 40% of the median award in state court. If an employee is unhappy with the outcome of arbitration, she is out of luck. There are no appeals for arbitration proceedings. These clauses are often buried deep into agreements, meaning most employees do not even know that they have signed away their right to bring suit in court.
Under the guise of consent, mandatory arbitration clauses allow companies to keep the public in the dark about misconduct, including sexual harassment. Remember Annie's non-disclosure agreement? If Annie loses her arbitration proceeding, she can never tell anyone what happened to her. In October 2017, actress Ashley Judd accused Harvey Weinstein of sexual assault. 1 week later, a movement originally started by activist Tarana Burke caught fire as a result of a tweet asking women to share their own stories of sexual harassment and assault with the hashtag #MeToo. Thousands of women then came forward to tell their stories. A number of high-profile men across entertainment, politics, and business were accused of sexual harassment or assault and were forced to resign.
You might be wondering why so many women waited to come forward. One reason is the arbitration clauses in their employment contracts. Journalist Gretchen Carlson is a high-profile example. After suffering repeated harassment by former Fox chairman Roger Ailes, Carlson was blocked from going public with her story because it violated a clause in her contract that would automatically channel future disputes into arbitration. Her contract ensured that in the sexual harassment case she eventually settled, all relevant allegations and events leading up to the arbitration would be held in strict confidence. In response to the Me Too movement, a number of important efforts aimed at ending forced arbitration have emerged. In Congress, bipartisan bills in both the House and Senate have been introduced that would exempt sexual harassment claims from forced arbitration agreements. In February of this year, a letter signed by every attorney general in the country was sent to Congress supporting the aforementioned bills. The attorney general stated that while there may be benefits to arbitration in other contexts, they do not extend to sexual harassment claims. Victims of such serious misconduct should not be constrained to pursue relief from decision makers who are not trained as judges, are not qualified to act as courts of law, and are not positioned to ensure that such victims are accorded both procedural and substantive due process. Facing pressure from social media and other advocacy campaigns, large corporations such as Microsoft, Uber, and Lyft have ended forced arbitration agreements for employees who file for sexual harassment. For too long, arbitration clauses have created a veil of secrecy that has perpetuated sexual harassment, allowing it to be underreported and underpunished. The unequal bargaining power of employee-employer relationships has maintained the fiction that consent and freedom to contract are at play in these scenarios. With the Me Too movement still on the public mind, with bipartisan and corporate support, now is the time for not only activists, but for the public, all of us, to push Congress and employers to give their victims their day in court, to give them the freedom to choose how they face their harassers, and to tell the world that sexual harassment will not be ignored.